My name is Dr. Nomsa Ingrid Zikalala from the University of South Africa, the Department of Police Practice. My topic is a comparative analysis of women's awareness of legal protection for microaggression in the Gauteng province. This is a table of contents. The introduction: ideally, social coercion in a modern society should eradicate or inhibit human conduct that threatens gender equality. Unresolved cultural practices and beliefs in some African communities legitimize inequalities. Legitimizing gender inequalities has exacerbated gender-based violence across South Africa. In 2024, the HSRC established that over 5 million women experienced a lifetime of violence since age 15, and over 3 million men experienced childhood physical abuse. Furthermore, family members were the most perpetrators of lifetime non-partnered violence in South African communities. Gender hierarchies continuously threaten the livelihood and safety of vulnerable groups. Vulnerable groups may experience offensive behavior such as abusive language, racist jokes, and a variety of aggression in different social settings. Subtle violence, termed microaggression, is prevalent worldwide. Microaggression is categorized as microassaults, microinsults, and microinvalidations directed at an individual or social group to prejudice or cause hurt. Although prejudice is harmful, it is not as regulated as discrimination. The effective policing of gender-based violence depends on the state's accountability to achieve its social responsibility. South African social responsibility is articulated in SDG 5 and 6. SDG 5 entails eliminating violence against women and promoting gender equality, and SDG 16 entails promoting effective and accountable institutions at all spheres of government. The definition of key concepts: gender, microaggression, and protection. Gender as a sex term, generally refers to the genital status of a person. However, there are various gender terms that do not assume this type of externalism. Microaggression was already defined, which entails a manifestation of prejudice which can appear as a microassault, microinsult, or microinvalidation directed at a person or a social group to cause harm. Protection is a term that refers to all activities aimed at obtaining full respect for the rights of individuals in accordance with the relevant body of law. The problem statement: the South African government has adopted CEDAW of 1979 and various international laws to protect women's right to dignity and restore positive gender relations in affected communities. The implementation of national and international laws against discrimination does not always guarantee women's safety. Studies show that 86% of women experience microaggressions such as sexist insult in public, and studies also show that 70% of women in South Africa do not feel safe in public alone. And underreporting of crime was also prevalent in South Africa. Factors such as the perception of police, education, socioeconomic status influence the reporting and underreporting of crime in South Africa. But many in South Africa are ignorant of the law. The RSA demographics show that 44 million illiterate adults have been recorded. Furthermore, the high school curriculum and adult basic education do not include law subjects. Hence, the majority of people get legal education from tertiary institutions. For example, UNISA College of Law has the second highest intake of students in comparison to 8 other colleges. So the knowledge of law and access to the constitutional, the criminal justice system, and the constitutional provisional institutions are a key achievement of gender equality as per the SDG 5 and SDG 16. Research on women's perception of the law is therefore of high importance. But of course, again, research on women's perceptions of the law may highlight barriers to justice and women's protection. The research objectives and the hypotheses were as follows. The aim of the study was to create awareness of how women from neighboring communities and municipalities in specific perceive the law against microaggression in Gauteng province. The objective of the study was to establish how women from proximate municipalities perceive South African law on microaggression. The hypotheses were how women from Ekurhuleni and Johannesburg do not differ in their perception of the South African Constitution on microaggression. HI Gauteng women perceive that South African Constitution protects women from microaggression. H2, Gauteng women perceive that the police manage microaggression directed towards females. The methodology, the research design was quantitative, descriptive, comparative research. The sampling, the study population was women residing in Gauteng. The target population was 2 groups from Johannesburg and Ekurhuleni. And the participation criteria was female age 20 between age 20 and 45, and they have to reside in Johannesburg or Ekurhuleni. The sample size was 80, and probability sampling, more specifically, the simple random sampling was used. Data collection and data analysis. Structured questionnaires with a Likert scale 1, 2, and 3 were used in a 30 minutes interview. An independent t-test was also conducted on SPSS to compare the mean score of the 2 groups. So the Likert scale was as follows. It ranged from 1 to 3. 1 was yes, 2 was no, and 3 was I do not know. In terms of the validity and the reliability of the questionnaire measured exactly what it intended to measure, and the results, generalizability, and the ethical considerations are also discussed. The demographics results were N, which is the total sample size was 80, female, and the majority, which is 97%, was male, who are black mainly. The ethnicity, majority 41%, it was mainly Zulu. And the highest age range was 25 to 30. And the majority, which is 58%, was women who had matric. And the results for the hypothesis was as follows. Ho was accepted, but H1 and H2 were rejected. And the results are as follows. With Ho, women from Ekurhuleni and Johannesburg reported similar perceptions on the South African Constitution on migration, which means the mean scores were the same. And the standard deviation was more or less also the same. And the sample size for the 2 groups, Ekurhuleni sample size was 40, and the Johannesburg sample size was also 40. H1, most respondents perceive that South African Constitution does not protect women from microaggression, and the mean score of the entire sample was 2. They rounded off from 1.8 to 2. The standard deviations was 0.4. The total sample size, of course, was 80. And the third finding was that most respondents perceive that police do not manage microaggression directed at females. And of course, the sample size was small, so the findings cannot be generalized. It got to ethical consideration. UNISA approved the study, and participants gave written formal consent to participate in the study. In addition to that, the study adhered to POPIA. The conclusions and recommendations were as follows. The conclusions was the t-test results showed that there were no differences in the mean score of the two groups' perceptions of the RSA law, which specifically returns to the Constitution. This implies that most respondents of the neighboring communities perceive that South African Constitution does not protect women against microaggression. Furthermore, most respondents perceive that the police, the SAPS in particular, does not protect women against microaggression. And the common trend identified in the comparative data was ignorance of the law. The study provides insight on South African women's lack of awareness of their legal protection from microaggression. So the recommendation as follows was that the government and the police could conduct awareness training programs to educate women on their legal protection from microaggression. This is the reference list. And the acknowledgement is, I would like to acknowledge the following people or institutions. That is one, the women in Gauteng who share the perceptions of legal protection from microaggression. I'd also like to acknowledge my supervisor, Professor David Masilwani, and the COD, Professor Angel Mabudusha, for the academic support. I'd also like to acknowledge the UNISA Law Ethics Committee for approving the study. And I would like to acknowledge my parents, Fieke Vermeulen and Willem van Harderwyk, for their support throughout the years. And on that note, I'd like to thank you for taking your time to listen to my presentation. And goodbye.